If you are in removal proceedings, is it still possible to do the waiver process? Let's say 10 years ago, someone tried to enter the border without inspection. They were detained and they were allowed to enter the US to seek asylum, and they were placed in removal proceedings. Now, as the years go by, they're participating in those removal proceedings and seeking asylum with an immigration judge. And they later get married to a US citizen and start a family. Now they have a spouse who's a citizen and they have kids who are US citizens. Well, that spouse can file an I-130 petition for the immigrant who's in removal proceedings. But after that petition is approved, since they are in court, they cannot move on to the 601A waiver process. So what do? Your options are either get the judge to administratively close those removal proceedings, in which case you can file a 601A waiver, or even better, if you were able to get the judge to dismiss your removal proceedings, then you can definitely continue with the waiver process. However, under this administration, we're not really seeing this happen. So if you are unable to get an administrative closure of your case and you're unable to get the removal proceedings dismissed either, then your only other option would be ask the immigration judge for voluntary departure so you can go back to your home country and seek the waiver there. But if you're genuinely afraid to return to your home country because of the reason that you were asking for asylum in the first place, you may need to do your consular processing through a third country where you have the legal right to present yourself. If you have questions about this complex process, click the link in my bio or leave me a comment below and we can schedule a consultation.